Does silence mean acceptance in construction contracts? It sounds like obvious, isn't it? But that's not the case. In today's video, we will explore an important question that if a contractor or subcontractor submits a tender with its own conditions of contract attached and these conditions are neither accepted nor rejected, do they still apply if the work is allowed to proceed? How does this situation relate to FIDIC contracts and general contract law? Let's break it down. In contract law, the general rule is straightforward. Silence does not mean acceptance. This principle, established way back in Felthouse versus Brindley in 1862, prevents a situation where someone can be bound to terms simply because they didn't reject an offer. In that case, an uncle wrote to his nephew offering to buy a horse, saying, "If I hear no more, I'll assume it's mine." The nephew said nothing, and the court ruled there was no contract, because the mere absence of a response doesn't create legal obligations. However, things can get more complex when we start talking about acceptance by conduct. While silence alone isn't enough, your actions might show you've accepted the terms. This was made clear in Brogden versus Metropolitan Railway Company in 1877. Here, a railway company received a draft contract for coal deliveries, and although they didn't formally agree to some changes, they still accepted the coal deliveries for 2 years. The court said that by accepting the coal, they had effectively agreed to the new terms, even without a formal yes. How does this apply to construction contracts? This concept of acceptance by conduct comes into play in modern construction contracts, especially with subcontractors and tenders. If a main contractor receives a subcontractor's quotation and allows them to start work without any formal acceptance or rejection of the terms, the courts could view this as acceptance by conduct. In other words, the contractor's behavior, letting work proceed, can be interpreted as agreement to the subcontractor's terms. A clear example of this in construction is the case of Gin Shaw versus James Scott Builders Company in 2010. The Shaws hired Scott to build a house, and a draft contract was prepared but never formally signed. Work began anyway, and when disputes arose later, Scott's conduct was interpreted as acceptance of the draft contract. The court made it clear silence doesn't equal consent, but taken during the project implied agreement. FIDIC contracts and acceptance by conduct. Now let's bring this into the context of FIDIC contracts, which are widely used in the construction industry to standardize terms and avoid ambiguity. FIDIC contracts have built-in mechanisms to prevent misunderstandings, like the role of the engineer in approving variations or changes, and the structured communication processes between the parties. Under Clause 3.5 of the FIDIC Red Book, for example, the engineer must make determinations and certifies approvals, reducing the risk of silent acceptance of new terms. However, even within the FIDIC framework, situations can arise where acceptance by conduct applies. If a contractor submits a variation and the employer or engineer allows the work to continue without formally approving or rejecting the change, courts could interpret this as acceptance by conduct. Similar to what happens under general contract law, the employer's or engineer's actions or lack thereof might imply they've accepted the contractor's terms by letting the work proceed. Take Clause 13, variations and adjustments, for example. If a contractor starts work based on a verbal variation and the employer or engineer doesn't issue a formal approval but allows the work to continue, there could be a claim for implied acceptance by conduct. Courts may look at the circumstances and determine that, despite the lack of written approval, both parties have acted as if the variation is part of the contract. Why this matters? In practice, silence rarely means acceptance, especially when formal processes like FIDIC contracts are in place. But that doesn't mean you can ignore a situation where work proceeds without a formal agreement on the terms. If a contractor receives a quotation from a subcontractor and doesn't formally accept or reject it, but lets the work start, the courts might see this as acceptance by conduct. Essentially, the act of allowing the work to move forward without objection can imply agreement to the terms, even when no formal acceptance is given. This is why it's critical to follow the formal procedures laid out in contracts like FIDIC. You want to avoid situations where implied acceptance occurs, leading to disputes later on. FIDIC's structured approach, with its clear communication lines, approval mechanisms, and the engineer's oversight, helps reduce the risk, but you still need to be diligent about formal approvals. We reach to end. Let's summarize the video and conclude the topic. In the construction contracts, silence alone doesn't seal the deal. The law is clear. No response doesn't mean acceptance. But here's where it gets interesting. Your actions can speak louder than words. You see, in construction projects, allowing work to proceed without formal approval can create binding obligations through what we call acceptance by conduct. This means that even if no one says yes out loud, continuing the work can imply agreement to the terms on the table. Think of it like this. In life, what you do often matters more than what you say. The same applies here. By simply letting the wheels turn, you might be entering into a contract you didn't fully realize you'd agreed to. And even in the structured world of FIDIC contracts, where every communication and approval is meant to be formalized, this principle holds true. If the work starts without a formal green light, the courts may still see it as a handshake agreement through your conduct. This can lead to real consequences, whether you intended it or not. So what's the lesson? Be clear, be formal, and never let silence or unchecked actions make decisions for you. Follow the proper processes, ensure every agreement is explicit, and never leave room for misunderstanding. Because in construction law, your actions can write contracts just as powerfully as your words.